Hey there, Jim Hart back at you here from, I gotta figure out where I'm looking at the camera today. All right, Hawthorn Law. And today I want to talk to you. This is such an important topic because I talk to so many clients, I talk to so many prospective clients about all the different mistakes that people make with their trademarks. And so today what I want to do is really kind of condense all of these potential mistakes that people make that I see all the time into a very simple list. I'm going to try and go through this relatively quick, but for right now, I just kind of want to talk to you about trademarks and the biggest mistakes that I'm seeing people make with their trademarks. So let's start with number one. What is a trademark? It's important to understand this because most people don't understand what a trademark is. Most people think a trademark is the same as a copyright, is the same as a patent. And really, all of these things are very, very different. And so a trademark, when we're talking about that, we're talking about a brand name. It could be a logo, it could be a design, it could be something else. So for example, this is a great example. I ordered this mug off of Yeti.com. It's got my law firm, if you can see there, it's got my law firm name on it right there. It's obviously got the Yeti design right there. Each of these things are trademarks, okay? My law firm, this is the brand that people recognize me for. I also run the brand Hawthorn Law. I actually do have a registered trademark for that. But Yeti is clearly a trademark. And so anyone, if I say Yeti to you, you probably know what that means. That's what a trademark is. It's the name or design or color. It could be like Tiffany, the jewelry, the boxes, the little blue box. That's a registered trademark for Tiffany because people recognize if you get a little box and it's in that Tiffany blue and somebody gives it to you, it's probably going to contain a ring or some other piece of jewelry. That's what a trademark is in a nutshell. And I think it's really important that people understand that. Most people don't. So with that backdrop in mind, let's talk about some of the mistakes that people make with regard to their trademarks. And the first one is, I think, probably the biggest mistake, especially for small businesses and entrepreneurs who are really trying to grow a brand, trying to grow a presence. They think that trademarks are really only for the big dogs, right? Trademarks are only for the Starbucks of the world, the Targets of the world, the Nikes of the world, the Apples of the world. Trademarks are only for those big companies, and nothing could be further from the truth. In fact, if you fail to protect your intellectual property, if you fail to protect your trademarks, then chances are one of those big companies is actually going to maybe come after you if you're infringing on their mark. So that's mistake number one, thinking that trademarks are only for the big guys. Trademarks are vitally important for anyone who is running a business, whether it's a small business, medium-sized business, whatever. They work for everybody. And we see a lot of people, solo and small entrepreneurs, filing trademarks, and that's because it's so important to do that. So that's number one, thinking trademarks are only for big companies. Number two is, and this one is really near and dear to my heart right now because I actually we had a potential client call us yesterday, and I was talking with my legal assistant today during our morning huddle about this particular person and the trademark that they had applied for. They had applied for it back in 2023 and no action had been taken on the file. The first thing that popped into my mind, my legal assistant was like, "What do you think is going on with that?" And I said, "Well, give me a second. Let me take a look at it. And I have an idea what I think is going on, but I'm not sure. Let me look at it." I looked at it. I looked at the record on the trademark office. Yes, the trademark was filed. It was filed by a service holding themselves out as a law firm. So that's mistake number two. You're hiring a service rather than a law firm. There are trademark filing services out there. They have to have an attorney that's filing the trademark. You cannot file a trademark application for somebody else unless you are an attorney. So if you hire somebody to do a trademark for you and they're not an attorney, they can't list their name on the application. Now, there could be services, I'm not sure about this. This kind of crosses into these gray areas of unlicensed practice of law, different things like that. But there might be services out there that will offer to prepare your application for you and then you file and sign the application. I don't know of that. I think that probably would be unlicensed practice of law, so I would steer away from that if you do hear about that. There's lots of people out there trying to scam people who are trying to file their own trademark application. But most of these services that you hire as a service, they have a lawyer on staff that may be filing the application for the clients. The problem is they're not really acting in that role as a lawyer. What they're doing is they're basically signing off on these applications and filing them because when you file applications with the U.S. Patent and Trademark Office, you have to be a lawyer. I just want to give you a couple of the quick benefits that you can expect if you did hire a law firm as opposed to one of these services. are obviously you're going to get advice and guidance regarding your trademark application. They'll be able to help you with a trademark clearance search before you file. They'll be able to make sure your application is prepared correctly and accurately. They will be available to respond to and receive correspondence from the USPTO on your behalf. So, you don't need to worry about missing any emails or missing any deadlines. Obviously, they can help you enforce and monitor your trademark application, make sure that it is protected once you do receive a registration. Probably most importantly, and this is kind of what I'm doing with this video, they can shield you from fraudulent solicitations from services or companies or things like that are not actually legit. So anyway, back to my story about this poor woman. She filed her trademark application with this service, but the service was actually a fraudulent service. So I don't know how much money she spent on this or what went into this, but I did look at it. I did a Google search of the person who was listed as the attorney on her application. It wasn't actually a licensed attorney as far as I could tell. And then I did a Google search of the email address that was listed, which was strange because it was a gmail.com email address, and you typically won't see that from a lawyer, although I guess it's possible for some old school lawyers that don't know how to set up email accounts. But I did a search of the email address, and sure enough, there were a myriad of articles about this particular company and the fact that they're filing fraudulent trademark applications. So in terms of why this person who filed this application back in 2023 has not seen any action on their application since then, it's because the trademark office is rightfully so treating this as a fraudulent application, even though the person who is the owner of this potential trademark is the victim in this case. It doesn't matter. The USPTO is still not going to prosecute this application for them in all likelihood. It's just going to probably sit dormant until they file a new one or they abandon this one. So another big question and misnomer, I guess you could say, that I get from people who are filing their trademark application is they think that they can add multiple names, multiple design logos, multiple elements to an application and just file everything at once. This is not accurate. When you file an application with the trademark office, it's one trademark per application, and that's it. If you want to file a second trademark, you have to file a second application. So it's one trademark per application. That's very important. A lot of people don't understand that. They can think they can file everything at one time, and you actually cannot do that. The fourth mistake I see people make is that they use a weak name. They find a name that they like, but it's really just a weak name. I've done other videos. I'll put a link somewhere up here to show you another video about how to pick a strong name. Basically, you've got generic names are the weakest type of names, then you've got descriptive names, and all the way up to fanciful names and arbitrary names are the most strongest names that you can pick for your trademark. And I do a whole video that explains all 5 different types of names that you can use when you're trying to pick a brand name for your business and which ones are the strongest and which I recommend you should use. Again, there'll be a link somewhere up here. I can never remember where they are. How am I going to know that? Mistake number 5 is that, and this is a big mistake, people do not conduct a proper search before they file their application. And so, again, this is something I see all the time, especially from people who try to DIY their own trademark. They come to my office, something's going wrong with their trademark application, they've received some type of initial rejection or refusal of their name, they're not sure what's going on or how to overcome it, or why their name can't be used versus somebody else's name that can be used. It's because they didn't do a proper search. And I don't know how to, I feel like I'm literally a broken record when it comes to this because I talk to almost every single client about this, about why it's important, why we need to do that. But you need to do that search because you want to make sure up front, before you waste 12 to 18 months on a trademark application and all the fees that go along with that, you want to make sure that you can actually register the name that you're seeking to register. And if there's another trademark out there that's substantially similar to yours or likely to cause confusion with yours, that's the legal standard that the USPTO uses, then it could delay or hinder or even prevent you from getting a registration for the trademark you're seeking. Not only that, but you could receive a cease and desist from another company that is using a name that's substantially similar to yours, and they can try and shut you down entirely. So then you may be forced to rebrand, And nobody's got time for that. Nobody wants to do that. So if you want to make sure you do it right, you need to do a search. And that's something that my law firm does for every trademark client. That's the first thing we do off the bat is we will conduct a search for you. Make sure your name is available. We'll advise you on that. Now, I will tell you, I've got clients that ignore my advice, and sometimes that's good, sometimes it's bad. I'm not perfect. I am a human, just like everybody else. I've issued opinions where I told somebody I did not think they could get a name, and they are able to get it. I've also issued opinions where I thought that a name is definitely available and they can't get it. This is a very subjective process, but it's important, especially if you're trying to figure out if there's somebody else who's using the exact same name as yours, that you conduct that comprehensive search. And a lot of times when a non-lawyer is doing this search, no offense to them, and if you're doing this, it's not your fault. It is a complicated process. I've done hundreds of trademark applications and hundreds of trademark searches over the years. It's hard. Sometimes it's a close call. Sometimes you can't say for certain whether or not there's going to be a problem with the name. So having an attorney look at that and give you advice on whether or not they think that your name is available is something that's very important and something you definitely need to do. Number 6 is not filing in the correct classes. It's funny to me, I have a lot of clients who come to me and they tell me what they're doing. We start working together. I'm running a search and I put together a list of classes and descriptions. And so this is what we're going to use in the trademark application when we get it filed. And so I always will send my clients a draft of what those classes and descriptions look like and the wording, and make sure that these are the actual goods or services that my client is selling or intends to sell in connection with their trademark. But this is something that I do all the time, and I can't tell you, I get a lot of clients who will come to me and say, wait a minute, shouldn't this be in this other class or shouldn't it be in this class? Again, it's somewhat suggestive, less so than the search. I didn't mean suggestive. Subjective, somewhat subjective. But generally speaking, when we're talking about classes, they're pretty rock solid. I mean, if you're in class 25, you're selling clothes. If you're in class 35, you're operating an online store with a website. So there's certain classes that are very common, we see all the time. But there's other classes like class 9, class 16 that deal with downloadable and non-downloadable, documents that are a little bit less recognized. So you definitely want to get some good advice on which classes you should be filing in, which classes you should include on your trademark application. Again, this is something I've talked to people about this in the past. The trademark application, is deceptively simple, but there's lots of different ways that people can mess it up when they file their trademark on their own. So I do recommend talking to a lawyer. I need a quick sip from my Yeti mug. All right, we're at number 7. This is a mistake that I see from people quite regularly. They assume I own my domain name. I own an LLC with the name of the business that I want to, brand and create as a trademark. I titled my blog the name of what I'm doing. I've got it on my t-shirts. I've got it wherever. That doesn't mean you have any trademark rights to that name. Just purchasing a domain name, just registering an LLC with a name, that gives you no trademark rights whatsoever. You could still be infringing on somebody and their trademark rights if you're using a name that's likely to cause confusion with a registered trademark that already has that name. So just because you own that URL or that LLC with a name does not mean that you own the trademark rights to that name. I've seen that from people all the time. I ask for specimens from clients. A specimen is basically proof that you're using the trademark in commerce. They'll send me their website with a URL and say, here, see how I'm using it? That doesn't mean anything. You have to be using your trademark in commerce in connection with the name, and that's something when you file your trademark application, you need to provide all the proof and evidence that you're doing that. Just owning a domain name is not sufficient. That's not going to pass muster with the USPTO. Where are we at? Number 8? 8, I think we're at. So number 8 is waiting to file. And this is an issue that I see people do all the time is they're like, oh, I'll do it later this year when I have more money. Oh, I'll do it, when my business gets off the ground. Oh, I'll do it when, this, that, or the other thing happens. Not a smart strategy. If you're building a brand and you're building a brand online and the world's going to know about your brand, then you really want to have that trademark filed as quickly as possible. And the reason why, I should say the trademark application filed as quickly as possible. And the reason why is because the USPTO, even though legally the first business or entity or person to use a trademark in commerce is the ones that has the first business entity or person who uses a particular brand name or trademark in commerce is the one who has rights to that name. Their rights are limited, and unless they've filed an application with the USPTO, those rights can be taken away from them pretty quickly. So you want to make sure you get your application filed, because that's going to give you your place in line with the USPTO, so that when they're reviewing applications, they will review yours before somebody else that may have come in and filed another application with a name that's, substantially similar to yours. So you could, I would be lying to you if I didn't say that I've seen applications where a client asked me to do a search, we did a search, and it came out in the search that a week before, a month before, somebody else filed a trademark for the exact same name or registration that would overlap with my client's trademark. So I see this all the time. Don't wait. Get your application filed quickly, because it could mean the difference between obtaining your trademark and not if you do this the wrong way. So that leads us to number 9, which is not monitoring or enforcing your trademark. Getting your trademark registered is only the first step of the process. Once you've received a registration for your trademark, you can't just sit in a drawer and forget about it. You actually have to actively monitor your trademark. We do offer an annual service for this, where we will, enter your trademark into our database, and we will get notified. We actually use software for this. We'll get notified by the software if another trademark comes up that is likely to be confused with yours. You may want to set up Google alerts for your trademark to know if somebody else is using a name that's similar to yours. So you really need to make sure that you're monitoring and enforcing your trademark. And along those same lines, trademarks don't last forever. They do need to be maintained. You need to file renewal documents with the USPTO. And so if you're not doing that, then you can, basically lose your trademark. So you want to make sure you're maintaining and enforcing your trademark, and you don't want to get in a situation where your trademark gets taken away from you because you stopped using it or you weren't monitoring it, and somebody else, canceled your mark or attempted to cancel your mark or something like that. So then we got the last mistake I see people make, and this is, again, one that is really unfortunate, but it does happen more often than you would think, and that is not using your trademark. So I get clients all the time that hire me. They're excited about their business, they're moving forward, but then they just don't ever start using their trademark. And if you file a DIY application and you're not using your trademark, you don't actually receive a registration until you're using it. You have to show evidence to the USPTO that you're using your trademark in commerce. You can't just file an application and never use it and expect to receive a registration. Trademark rights are tied to use in commerce. You can't just squat on a name and hope that nobody else is going to use it, or receive a registration based on the fact you filed alone. Now, there are exceptions. There are ways that you could file a trademark application and not show use and still get it, but typically this is going to be reserved for international applications and different things of that sort. There you have it, 10 mistakes that I see people make all the time with their trademarks. Hopefully you found this helpful. If you did, here's another video right here talking more about trademarks and why you need them for your business. I'll see you next time. I hope you have a great day. Thanks, folks. Bye-bye. Oh, I almost forgot. Link down below. If you'd like to talk to my firm, obviously I'm a trademark lawyer. Link down there if you are interested in getting started with my firm and scheduling a free call to figure out whether or not we can help you with your trademarks. That's it. Have a good one. Peace. Peace. I'm always looking at the wrong thing. See this? You're not here. You're here. All right. Bye-bye. See you later.